Welcome. Good afternoon, everyone. Welcome to the National Trust's webinar, Section 106, Regulations Under Threat. And this webinar will drill down and share specifics on the technical complexities of the proposed changes to the Advisory Council's regs. I'm Rob Nieweg. I'm a senior vice president at the National Trust, and I'm hosting this webinar. We have an excellent pair of preservation leaders and subject matter experts to speak with you. We also will be answering questions that you may pose in the Q&A function. So bear that in mind. Chat function is open. Enjoy the exchange. We have allocated a segment later in the webinar to address questions. We're going to begin by addressing questions that were shared during our last webinar about this same topic. So we may start there and then go to questions posed today. We encourage you to communicate with all participants in the chat. And you should know also that the closed captioning function is available during this webinar, and you can enable it yourself or disable it using the controls at the bottom of your own Zoom screen, based upon which version of Zoom that you're using. While you are participating in the chat, we ask everyone, of course, to be respectful of each other in your exchanges and to follow our code of conduct, which I think Priya will link to in the chat right now. Following the webinar, as we always do, we will send out a recording of this webinar to everyone who's registered. We'll use the we'll use the email address that you registered using to communicate with you. And then all of our webinars are archived at the National Trust's YouTube channel. You can see here that we will hear from preservation leaders, subject matter experts Sprague of the National Trust and Betsy Merritt of the National Trust. Let's dive straight into the specific technical complexities that are confronting us here. I'm passing the microphone to you, Shaw. Thanks very much.
Thank you, Rob. It's a pleasure to be with everybody today. I'm Vice President of Government Relations, so that will be the focus of my comments today. And it really is inspiring to see so many people from all around the country jumping on today. We appreciate your attention. As Rob mentioned, this is a follow-up to our July 30th webinar on Section 106. During which we received a number of communications that we wanted to respond to, including distinguishing between legislative and regulatory actions, what is concurrently happening on Capitol Hill around changes to Section 106, and what you can do now to take action. But before I turn the presentation over to Betsy Merritt, I did want to describe the broader policy context and clarify some of the dynamics between statute and regulation before getting into the more technical concerns that we wanted to share with the proposed regulations. So quite simply, a statute is a formal written law passed by the legislature, and a regulation is the administrative rule created by the executive agency, in this case, a CHP, under the power given to it by a statute, in this case, the National Historic Preservation Act. So it's helpful to think of it like statutes setting broad policy goals while regulations add the specific details and processes to implement that. Both are binding laws, but regulations cannot go against the underlying statute that created them. So If this were to occur, courts can invalidate a regulation and strike it down as lacking legal authority. Interestingly, in June 2024, the Supreme Court in Loper Bright versus Raimondo overturned the longstanding Chevron doctrine that established significant judicial deference to administrative interpretation of statutes where the intent of Congress was not entirely clear. So what this means is that today courts have more flexibility to independently interpret the statute in question where legislative intent may not be clear. So it's an interesting backdrop for this particular moment. Next slide, please. So we're today focused on the specific proposal that ACHP approved on July 24th and is pending administrative review. But I also wanted to call attention to the bipartisan efforts in Congress to advance permitting reform legislation. And many of you, I'm sure, recall that last October, the Senate Energy and Natural Resource Committee held a hearing examining NHPA Section 106 in its attempt to identify ways to improve the process. By our estimation, this is the first time a Senate committee dedicated a full hearing to this specific issue. So it's very much on the minds of legislators right now, and they are working on this. The committee had set an informal goal to introduce legislation before the August recess just a few days ago. So there were headlines that you may have seen announcing that they were going to not be able to introduce that legislation, the broader permitting bill legislation. But both sides of the aisle are intent and focused on introducing legislation as soon as they can. So that can be September. It could happen, it could slip again and possibly occur during the lame duck session of Congress. I think there's only a few weeks in September when both chambers are back in session. So we'll just have to see, but this is happening concurrently. So we want to make sure everybody's aware of that aspect going on in Washington right now as well. I'll just note the House is not as far along in its examination of statutory reform around Section 106. But it is important to understand how changes to statute would impact proposed regulations. Next slide, please. So here I wanted to just dive into the understanding the relationship between statute and regulation a bit more. So consider the following. Statutes are passed by Congress and signed by the president. They establish binding legal requirements that define the authority and limits of federal agencies. And they can amend, supersede, or constrain existing regulations. Regulations, on the other hand, are developed by an agency pursuant to the authority granted by Congress, and they provide details and procedures for implementing the statute. Regulations must remain consistent with the statute and can generally be changed by a subsequent administration through the rulemaking process. The takeaway here is that regulations implement statutes, they do not replace them. Next slide, please. So here again, a helpful breakdown of what regulations can and cannot do. They can establish procedures, define how agencies conduct consultation, create timelines that are consistent with the statute, and establish exemptions and alternatives where authorized. But what they cannot do is contradict the statute, eliminate statutory obligations, override congressional requirements, rewrite congressional authority, exercise authority that Congress did not grant, or supersede subsequent legislation. In the case of ACHP, Congress has given ACHP substantial discretion to structure the 106 process, which makes the boundaries and congressional direction that we do have all the more important to understand. Next slide, please. So why are the ACHP's proposed regulations so significant? Regulatory reform can have a massive impact on the underlying statute. So the concern isn't necessarily that ACHP can legally repeal Section 106, but regulatory changes can substantially affect what projects receive review, what geographic area is considered, which historic properties are considered, who participates in consultation, how long this consultation might last, when consultation can be terminated, how agencies document these decisions, and how tribal and community interests are incorporated into that consultation. On the right-hand side, I wanted to put the statement from the Senate Energy and Natural Resource Committee ranking member, Martin Heinrich, and colleagues, Democrat colleagues on that committee in the days following the ACHP's announcement of the proposed regulations, asking them to go back to the drawing board and how they would reduce consultation for tribes, states, and local communities. So it drew this immediate response from Capitol Hill, an immediate response also from the ranking member of the House Natural Resource Committee. So the Hill is very much aware and taking notice of this rulemaking, and they have concerns. Next slide, please. So the point here is that Congress can change the equation. Congressional action can establish specific procedural requirements that an agency cannot simply change through subsequent rulemaking. So suppose Congress says in its subsequent legislation for projects affecting historic properties, the agency shall consult with the SHPO and affected tribes before making a final decision. An agency regulation could not then issue regulations that say consultation is unnecessary when the agency determines that consultation would delay a project. Conversely, if Congress instead simply says agencies shall take historic properties into account, then it leaves considerable more discretion to the agency to determine how that obligation is implemented. The takeaway here is that the more specifically Congress legislates, the less room future administrations or current administration have to reinterpret the policy through regulation. Something that the preservation community needs to be thinking closely about. Next slide, please. So what can advocates do? If you attended our last webinar, many of these advocacy actions will sound familiar, but we wanted to dive into a little bit more detail. One of our first requests is that organizations and stakeholders submit a meeting request with the Office of Information and Regulatory Affairs, OIRA. So under Executive Order 12866, OIRA meets on regulatory actions with any interested party to discuss issues on a rule under review. If you request the meeting, it does not necessarily mean you'll get that meeting, but your interests, you have a right to be heard and understood, and this is open to, again, any interested party. So it's your right to request a meeting, and you should do so. And we're also encouraging you to request that your governors also request these meetings. On our website, we have a template letter that you can send to your governors to assist with that. But that's an important message. We want the governors to be aware of these issues and weighing in. I wanted to point out here that the regulation identifier number, the RIN number assigned by OIRA for ACHP's amendments to the implementing regulations for Section 106 is 3010-AA10. Next, we're in the middle of our the congressional August recess. Both the House and Senate are in recess. Members are back home in their communities. Reach out to their district offices. Ask to meet with the members if you can, if you're comfortable with that. Meet with their staff. Meeting with staff is perfectly good way to communicate those concerns as well. It's also a great opportunity to meet in a less hectic environment than Capitol Hill. You often get a bit more time in a more relaxed atmosphere to have those conversations. So make that request, make those connections, meet the staff. It's really important, and it's going to become increasingly important in the weeks and months ahead. We're also asking that you start to think about and prepare your comments. In our last webinar, we asked that you weigh in during the public comment period for these regulations. It's important that the preservation community have a show of force and register concerns and those comments. It's a really important part of the process. I'm going to cover the timeline in just a moment here to break that down in our best guess, really, as to when that might occur. But in the meantime, please be thinking about how your comments will, what you want to say, examples of successful Section 106 consultations in your community, and how your community might be worse off without this ability to consult on federal undertakings in your community. Also, please keep an eye out for the introduction of the federal permitting legislation. Again, it could happen in September or possibly in the lame duck session of Congress. Let your members know what you want to see in the bill, and that you have an interest in shaping what ultimately becomes part of the final bill. And lastly, if you haven't tuned in to our National Preservation Summit in Washington, D.C., would encourage you to look into that. As part of that summit, there is an advocacy day on September 24th. You should feel free to attend the summit, of course, but we certainly welcome you coming down just to participate in the advocacy on the 24th. It's really going to be an important opportunity to support historic preservation in our nation's capital. And then finally, at the bottom of the screen, you can see the, previous slide for just a moment. I wanted to flag that all this information and additional details, letter templates can all be found at savingplaces.org /section 106. So make sure you're fairly regularly checking back at that website, and you'll have the most up-to-date information that we are providing. Next slide, please. So just walking through the timeline so people have that. ACHP vote, as folks will recall, was on the 24th. That immediately goes to OIRA for review. There is no statutory deadline for OIRA to respond to the regulations. Perhaps in part that will be determined by how much interest they hear from stakeholders, how many meetings they intend to hold around these regulations. And again, if you request a meeting, it doesn't guarantee that you will get a meeting, but we think it's important to register the interest from the community here. But we don't know when that will come back to ACHP. But once it does, ACHP will then publish its notice of proposed rulemaking in the Federal Register for public comment. We are anticipating that the public comment period would be 30 days. And what we are attempting to do is to be as prepared as we can as a community before that happens, so that we can effectively advocate during that period. ACHP will then review the input and comments it receives. It will then resubmit. It will potentially make changes depending on what instruction it receives back from OIRA and how it wants to respond to comments. That could require another vote by the ACHP, but it will go back to OIRA after that period. And then it will then, I'm looking at OIRA here, it goes back to OIRA. So there's a back and forth between the interim rule and then the final rule. Before that, you'll see tribal consultation occur, a final vote on by ACHP, final rule published in the Federal Register, and once that occurs, that would then potentially ripen into litigation should parties pursue that route. But again, we don't have a precise grasp on the timing of all this. It's a bit of it's a different process than we are accustomed to. As you may recall, the initial regulations were voted on within a week of being introduced. So that is the timeline, and now I will turn it over to my colleague, Betsy Merritt.
Greetings. Let's see, I've got to get my camera on. Oops. Sorry about that, technical difficulties. Greetings, I'm Betsy Merritt. I'm Deputy General Counsel at the National Trust. And we warned you this was going to involve technical complexities, but we are delighted that so many of you are nonetheless willing to dive in with us. And I'm going to start by focusing on some of the specific ways in which the Advisory Council's proposal is directly in conflict with the language of the National Historic Preservation Act, and therefore unlawful. A key part of our advocacy messaging at this stage is to make the point that this proposal is severely vulnerable to legal challenge. It will be challenged in court. And after months or years of litigation, we believe the courts will conclude that the proposed regulations are unlawful. The chaos and uncertainty this would cause is not in the public interest, and indeed would be extraordinarily harmful. And that chaos and uncertainty would be exacerbated by the proposed changes in the statute that you've heard about from Shaw. From the perspective of project developers and industry representatives who want to streamline the review process and make it more predictable, none of that is helpful. So we want to persuade the administration that the blatant contradictions between the Advisory Council's proposal and the statute make these proposed regulations so vulnerable that it would be wiser to withdraw the proposal altogether. We will first try to persuade OIRA to reject the proposal, and then if the proposal is published in the Federal Register, we will make the record through our comments collectively, and if necessary, we will challenge the regulations in court. And I know we will have lots of partners in that approach. So let's get into the weeds here. The language of Section 106 itself on the screen is very brief and leaves lots of room for interpretation, like the term take into account. The long-standing Section 106 regulations spend 16 pages of fine print defining what this means and how it happens. As you'll see, most of the statutory inconsistencies between the Advisory Council's radical new proposal and the National Historic Preservation Act are violations of other National Historic Preservation Act provisions, as opposed to Section 106 itself. However, even some of the language of Section 106 itself conflicts with the proposal, and the highlighted words are some of the ones we'll be reviewing in more detail. Okay, next slide. This is the statutory definition of undertaking in the National Historic Preservation Act. The key thing here is that the undertaking is not the federal action. The undertaking is the project itself, which is often a state or local or private project that may require a federal permit or federal funding. So it then becomes federally licensed undertaking or federally assisted undertaking, but the undertaking itself is not the federal action. Next slide. Now, I'm including some images from the red line document prepared by the Advisory Council, so you can see firsthand how dramatic some of these changes are. Here's the revised language proposed by the Advisory Council. So as you can see, they attempt to limit the definition of undertaking to federal undertakings only. And this is squarely inconsistent with the statutory language of the National Historic Preservation Act. And note also the sloppy grammatical error in their proposed language where it says a federal undertaking which Section 106 analysis is required. Next slide. Here's some additional language from the Advisory Council's proposed new definition of undertaking. So here are some additional ways in which they're proposing to cut back in ways that violate the statute. So these new provisions would eliminate from the scope of the undertaking any portion of the project that the federal agency doesn't have direct jurisdiction and control over, even if the ultimate project would not be able to go forward but for the federal approval. Army Corps of Engineers permits are sort of the classic example of this kind of issue, where it's very common for private development projects to require Army Corps permits for a very small portion of the project that may affect wetlands, for instance. But the permit is essential for the project as a whole to go forward. Even in that case, the Army Corps is currently required to consider the impacts of the entire undertaking. But under the new Advisory Council proposal, they would only be required to look at adverse effects within the wetlands that are under their direct jurisdiction. Next slide. The language proposed by the Advisory Council also says that if a state or local government is exercising delegated federal authority, then no compliance with Section 106 is required. Well, one of the key programs that would be exempted from historic preservation review altogether under this language would be HUD programs, such as community development block grants, which are often delegated to local governments to manage. But in addition, 9 states, the ones listed on this slide, have longstanding arrangements with the Federal Highway Administration where they have delegated legal authority to manage federally funded transportation projects. And under current law, those state DOTs are specifically required to comply with federal environmental and preservation laws. And if a lawsuit is filed to enforce compliance, for example, the state attorney general is the one required to defend it. Under the proposed language, all federally funded transportation projects in these 9 states could be completely exempt from Section 106 review. That's pretty radical. Next slide, please. In another attempt to eviscerate Section 106 review, the Advisory Council's proposal would explicitly eliminate consideration of all visual, atmospheric, and audible effects, all reasonably foreseeable cumulative effects, and all effects that fall outside the agency's regulatory jurisdiction. So for a project like the president's proposed arch, which has been in the news a lot lately, even though the National Park Service has identified 37 different historic properties that would be adversely affected by the project, and the consulting parties have identified many more, virtually all of those adverse effects would be visual and therefore not even required to be considered at all under the proposed regulations. Next slide, please. Here's a slide that shows some of the new language introduced by the proposed regulations that would dramatically reduce the historic properties protected by Section 106. It has to include, in order to be considered, tangible human improvements, and it must be, quote, geographically compact. Now, how do we define geographically compact? Sounds like an issue that would generate lots of litigation. This suggests that Civil War battlefields, for example, would be completely unprotected. Next slide. And then to twist the knife, here on the right side is proposed language from the Advisory Council that says mountains, valleys, bodies of water, or landscapes, including ethnographic landscapes, do not qualify as historic property under Section 106. So it would not have the effect of delisting them from the National Register, but adverse effects on these resources would not have to be considered at all. So if you have a massive industrial facility right next to the Grand Canyon, for example, no problem under Section 106. Now, on the left side of this slide, I've inserted the statutory language from the National Historic Preservation Act, so you can see how inconsistent it is with the proposed regulations. This is one of the most dramatic contradictions. Next slide. Now, I also want to flag the dramatic reduction of the SHPO role in consultation under the Advisory Council's proposal, which again is directly contradicted by the statutory language. SHPOs would only be involved in consultation at the discretion of the federal agency and only after the fact. By contrast, here's the statutory language that describes the roles and responsibilities of the SHPO. Advise and assist federal and state agencies in carrying out their historic preservation responsibilities. Consult with appropriate federal agencies on federal undertakings that may affect historic property, etc. And so now you've got a statute that says, here, go to the next slide, please, and you can see some of the language. So I wanted to include some of these actual red line sections so you can see how dramatic some of the changes are. In the first line, it says the following parties may have consultative roles in the Section 106 process, whereas it used to say, they have consultative roles. That's one change. And you notice they deleted the sentence that says the SHPO reflects the interest of the state and its citizens in the preservation of their cultural heritage. Why is that deleted? Anyway, this shows you that part of the provision that diminishes the role of the SHPO and brings in SHPOs only at the discretion of and at a delayed timing as set by the federal agency. Okay, next slide. Okay, now we're going to go to the local governments. This is the statutory language, and local governments, like SHPOs, are now involved, or would be involved if the Advisory Council's proposal goes through, only at the discretion of the federal agency and at a later time in the process. So the statutory language says the council's regulations shall provide for participation by local governments with respect to undertakings that affect the local governments. And so let's go to the next slide and I'll show you here's the change in the regulations. The agency official may invite a representative of a local government. It used to say that the local government was entitled to participate as a consulting party. No longer under this proposal. Next slide. Okay, tribal consultation is another arena in which the advisory council's proposal would eviscerate the role of tribes in the consultation process. And I wanted to show some of the shocking revisions to the language that are being proposed by the advisory council here. As you can see, they have entirely deleted the sentence that says the agency officials shall acknowledge that Indian tribes and Native Hawaiian organizations possess special expertise in assessing the eligibility of historic properties that may possess religious and cultural significance to them. Completely deleted. And again, like with local governments and SHPOs, the agency determines whether and when to consult with tribes and Native Hawaiian organizations. And notice also that it has the agency itself making the determination, essentially unilaterally, whether properties are eligible for the National Register. So next slide. We also wanted to highlight the dramatic reduction of the role of the public in the consultation process. And this is of special concern to the National Trust because of the fact that our congressional charter requires us to facilitate public participation. And so this is an issue that we're especially troubled by. And here you can see again some of the dramatic revisions to the language in reducing public involvement and leaving it completely up to the agency to determine sort of how and when and whether to involve the public, and suggesting that the agency engage in a balancing exercise where if there would be costs involved or other interests that might weigh against public involvement, that those would affect the agency's decision as to how much weight to give the public comments. So, and I know this is a lot of fine print here, but we'll be sharing the slides after the fact if you want to sort of go back and take a close look at some of these pretty shocking revisions. Next slide, please. Here's some additional language about the limited role, the more limited role of the public. So, for example, in developing programmatic agreements, the agency may consult with SHPOs, TIPOs, tribes, and the public in developing programmatic agreements. And notice the provision that is deleted completely. The agency official shall arrange for public participation appropriate to the subject matter and scope of the program. Completely deleted. So that's another example that we just wanted to highlight of radical revisions being proposed here. Next slide. So the bottom line is that, and there are many other inconsistencies that we haven't gone through because we do want to save time for questions. But the bottom line is that the uniquely effective dynamic of consultation under Section 106, which has been so successful in leading to so many win-win outcomes, so many agreements where through modifications and alternatives to projects that have the effect of avoiding or minimizing their adverse effects through the consultation process, that dynamic would now become purely optional. And there's no incentive for the agency to reach agreement. Instead, the agency would make its own unilateral determinations and then submit a Section 106 report after the fact, afterwards, for comment. And then, receive comments from the parties, but there's not the same level of incentive to reach agreement. And so many of the fundamental aspects of the Section 106 consultation process that has been so successful would be completely obliterated by these proposed changes. So at this point, I will hand the mic back over to Rob, I believe, and we can take some questions that I think have been coming in on the website. But thank you again for walking through these technical complexities with us, and we look forward to continuing this conversation.
Betsy, thank you. And thank you to Shaw as well. Good. Shaw, Betsy, both up. I want to share questions that have been asked in the chat now, and also some compiled from our last webinar on the same topic. Know that if we don't address your questions here live, we're working on a frequently asked questions online function that can be helpful. Okay, so Betsy and Shaw both, and don't hold back. If the proposed rule changes are approved, talk to us about how those changes would affect project consultation currently in process, but also how might those changes in the regs impact existing programmatic agreements or existing memoranda of agreement. Address that, please, either of you.
I'll take a stab at it. There is a provision in the proposal that says any consultation that started before the new regulations go into effect will continue under the old regulations unless the project sponsor requests for the evaluation, the consultation to proceed under the new regulations. So it does give the project sponsor the option to, switch over to the new regulations, which would pretty much eliminate the consultation, presumably. And it says, for 1 year after the effective date, a project proponent may elect to undertake consultations, I guess under the old regulations. It's a little unclear. The language is a little unclear, and I actually think that this will be one source of significant controversy and conflict, confusion about consultations that are incomplete, and where applicants and project proponents will want to switch to the new, get out of jail free card.
Right. And how about MOA or PAs that are already signed, existing ones?
I don't see anything in here about revoking existing agreements, although most of them do have termination provisions in them. And so we might see situations like what the Army is starting to do, where they're just terminating every single agreement they have all across the country by invoking the existing termination provision. That's one option.
Okay, thank you.
And Rob,
So,
I might just also just add on that, that could be one of the things that is addressed through the current OIRA process. So there was a question about meeting with OIRA. Questions to OIRA could include status of existing agreements and a request to address those more specifically. So it could be something that over the course of the coming weeks is more specifically addressed before a final rule is published.
Okay, Shaw started by saying, let's say you're a local government. Let's say you have the ear of your governor. Get that local government or get that governor to request an OIRA meeting. There was a good question in the Q&A about, well, if you got that meeting, what would you ask? We'll be providing more insights into that. Lots of questions on how would, if they were enacted, established, how would these new regs impact other kinds of historic preservation protections? Section 110, Section 4F. Let's take on Section 110 first. Somebody want to answer?
Well, they don't directly change Section 110. The statute would, of course, remain the same unless Congress modifies it. But any projects that an agency, a property management agency undertakes that would affect, for example, landscape type historic properties would not have to go through Section 106 consultation, even though you'd have the general stewardship responsibility that would remain in place. But you wouldn't have to go through consultation for a project that under current regulations would have adverse effects on historic properties.
Thank you. Lots of conversation in the chat, but also in Q&A about impacts to Section 4F. Do you want to take that on?
Well, 4F might be our saving grace because it wouldn't be eliminated by these regulations. However, there are provisions in here that say if you've got, for example, a categorical exclusion under NEPA, then you can skip Section 106. And so there's nothing that directly addresses Section 4F, but I'm sure there would be efforts to try to eliminate that as well.
Thank you. So, Shaw, to you, help us to understand, clarify what could Congress do? What say does Congress have regarding the approval of the proposed new regs?
Right. So this is an agency action, and so Congress would need to, its primary response would be legislative in nature. So that is the primary way that congressional offices have been thinking about this. Other thoughts of ways they might respond. The appropriations process often will include different riders and communications about how it wants to see agencies carry out regulations. They have the power of the purse that presents opportunities. You see that being discussed in other sectors. You see efforts to introduce legislation to nullify regulations. Those, I think, have a difficult path to enactment, but they can still serve an important purpose in the current environment. But really, I think their options are limited in terms of stopping of regulatory action from going into effect, short of passing legislation.
Okay. Shifting gears somewhat, Betsy, to you. last time question, this time question. Are you concerned that these very significant changes to Section 106 would impact state and local statutes and regs that mirror Section 106?
Yes.
What are the ripples?
Yes, definitely. We would. There are many state and local governments that do rely on the federal Section 106 regulations as sort of a model, either literally or indirectly for their programs. And we do worry that it would undermine many state and local regulatory frameworks, regulatory setups for historic preservation.
So, likelihood of harm to state and to local. Other thoughts, HP protections, other thoughts about how these proposed changes might impact certified local governments?
Well, the fact that local governments no longer would be entitled to participate in Section 106 consultation and would be sort of notified after the fact would be devastating and on many levels. And so their rights would be dramatically curtailed.
So a role for local government, a role for state government in this advocacy about the ACHP proposed regs. Is there something specific that we might be asking our state historic preservation officers to do at this time, Shaw?
Well, certainly the SHPOs are deeply engaged in the rulemaking. The National Conference of State Historic Preservation Officers has a voting role on the ACHP and is represented there, of course. But in terms of like the individual SHPO offices, they are part of their state governments, and I think if governors' offices are hearing from constituents about these concerns, those governors are more likely to call on their SHPO for greater clarification and understanding of the impact of the proposed regulations, and give individual SHPOs perhaps more opportunity to weigh in with specific concerns with their governor's offices. So they'll play a very key role in educating state leaders on how and if they weigh in.
Shaw, could those impacts to our state historic preservation office include loss of funding, loss of staffing, even the existence of a SHPO, if this proposal is established?
I think to Betsy's earlier point, if these regulations are to go into effect, the chaos and the confusion that would ensue would be significant. Of course, SHPO offices are funded both through grant funding at the federal level and the state level. The federal appropriations process is separate, and we continue to advocate for strong funding for SHPO and TIPOs at the federal level. But in terms of how states respond to a more limited role in the SHPO office, that is, I think that remains to be seen.
Okay. Rhonda, I don't know if you can go backwards and show that timeline slide. And then my question to Shaw and to Betsy is upcoming, we have a few minutes, upcoming there, opportunities for public comment. So it's fundamentally when it's in the Federal Register, yes?
That's
Mhm.
correct.
Yeah.
And Betsy, I'll let you weigh in with more detail here, but we're anticipating a 30-day public comment period. I think what we're asking the community to do is to be prepared for an even shorter public comment period should the process not proceed as it might normally proceed. But that is why we're asking everybody to think about that now and prepare for when the public comment period opens.
Okay, and it's likely to, let's say it's 30 days. That's the one bite at the apple.
Well, so we've seen some comments about the interim proposed rule and a final proposed rule, and some concern, and we've heard this expressed from the outset, that could ACHP and the administration move directly to a final proposed rule with a 30-day public comment period. That is not how ACHP has described the process to the council. They have described it as having, a 30-day public comment period for the proposed rule and another 30. Well, we don't know the number of days, but another public comment period after the final rule is published. So, 2 bites at the apple is how it's been explained. But again, you don't have complete certainty in this.
Okay. And first of all, this webinar has been recorded. This webinar will be sent back out to you using the email that you registered by, and it will become archived. But we fundamentally have 2 things going on in our preservation world. One is legislative initiatives to change 106, permitting reform. Yes, Shaw? And the other is the ACHP proposed really radical evisceration of Section 106 that Betsy pointed to. I like the question in the Q&A about a section-by-section analysis of what is being proposed. We're working as fast as we can. Look at our webpage for online resources, and on our webpage, we cross-link to other sources of information that you can draw from. We're all in the middle of this. We're all trying to figure out what is going on and how we can be effective strategic advocates for Section 106. And we have heard all these great questions about the ripple effects and the other things that can happen because of this change. We're happy to have hosted everybody. Next slide, please. Upcoming webinars hosted by the National Trust. Take a look at these. You can go to our webpage to see upcoming webinars that are coming. You'll see that on August 24th at 2 p.m. Eastern, we intend to have a 3rd webinar about Section 106 regs under threat. And that one would focus, we hope, on guidance for advocates and guidance for activists who want others to advocate on these very complex topics. There are other great webinars also happening. If you want to learn about upcoming programming, savingplaces.org, upcoming webinars. That makes perfect sense. Click to the next slide, please. For a real deep dive, come to the National Preservation Law Conference, October 19th. Make your hotel reservations. Next slide, please. Thank you. Thank you to Betsy, and thank you to Shaw. Thank you to everyone in the chat, and thank you to those of you in the Q&A. You know we conserve both the chat and we conserve the Q&A. We have the frequently asked questions coming to you, and we also look at what you're calling for. What are the needs in the preservation movement to be able to respond strategically to what is happening? Thank you for coming out. Thank you to Priya, thank you to Rhonda, and everybody behind the scenes who make these webinars happen. If you have questions, get in touch with us at forum@savingplaces.org. That's it. We are adjourned.